Many listing agents are dealing with sellers who recently purchased a property and now wish to fix and sell the property. This is a common practice and often helps a community when distressed properties are fixed up or remodeled. If the buyer is seeking to obtain a FNMA, FMAC, USDA, FHA, or VA loan, most lender underwriters require that the seller hold the property for 90 days before they enter into a contract for sale. There are some exceptions to this rule, yet it is common for the underwriter to stop the transaction once it is determined that the seller has not held the title for 90 days. Thus, a seller and their listing agent would be obligated to disclose to any buyer the length of time that they have held title, especially if that is less than 90 days. Without this disclosure, a buyer might pay for an inspection, an appraisal, loan fees, applications, and even moving before the underwriter says no and rejects the deal. Remember the 90-day rule. A buyer is not even able to sign an offer for purchase until the 91st day of a flipped home. If you are working with the seller, make sure they record the deed as soon as they purchase the property to flip, so that there is not lag time in waiting for the 90 days. Another concern in these fix and flip transactions is the seller's typical refusal to complete a seller's property disclosure statement, SPDS. Their argument is that they never lived on the property, and thus could not complete an SPDS. Let's dissect that situation. First, when the fix and flip seller bought the property, did they conduct an inspection when they purchased the property? If so, did that inspection reveal potential material and/or latent defects? Did they obtain a SPDS from a previous owner? If so, again, did the SPDS reveal any potential defect? Does the current seller and you, the listing agent, assuming you were the agent that helped them buy that property, have the previous inspection and the previous owner's SPDS in your possession? Assuming you both do, you both have a duty to disclose whatever was disclosed on those documents. Then we must ask, did the seller remodel the house, and in doing so, did they remove carpet, tile, counters, cabinets, etc.? Did that reveal any mold, previous termite infestation, structural problems, etc.? Of course, if the current seller bought the property at a trustee's sale, did not inspect the property, and did not obtain a SPDS, they still worked in the property to get it ready for sale. They obviously saw things that could indicate a material or latent defect. The listing agent, you and your broker, would take on heightened liability if your seller refuses to disclose what they know. This matter gets more complicated when the seller is the licensee. Sure, as licensees, we should buy and sell real estate and use real estate as an investment. What might complicate the matter is if the broker allows the listing agent to buy, fix, and flip, yet does not insist that the listing agent seller complete a SPDS. Most errors and omissions policies do not cover agent-owned transactions, so the broker accepts a higher liability in such a transaction. To protect the brokerage, the broker might require that the listing agent seller provide a detailed SPDS. The seller, if flipping, knows who the utilities are with, and many other questions on the SPDS. There is no reason that they are not able to fill this form out for the buyer. Scenario: the seller owned the house for 8 years, saw the house once when they bought it, and has had a tenant in the property since the day they bought it. Now the property is vacant, the seller lives in Cleveland, and they ask you to go there and assess the condition. You do that and report back to the seller with photos and details of what you saw. Now that the property is cleaned and fixed, you list the property for sale. The seller refuses to complete the SPDS, arguing that they never lived in the house. A buyer writes an offer, seller accepts, and the buyer conducts an inspection. On day 6, the buyer sends the BINSAR via email, canceling the contract, stating that numerous and serious problems with the property, specifically the roof leaks and the pool surface is cracked. The buyer, according to the AAR residential resale purchase contract, provides a copy of the inspection report with the BINSAR. At that point, you would forward the email with buyer's cancellation and the inspection report to the seller. Now, you put the house back to active in the MLS. As a result, Now you and the seller have the inspection report identifying potential material and/or latent defects in the property. What would you do as the listing agent? Could you convince the seller to complete a SPDS based on the inspection report and provide that to subsequent buyers? Provide a subsequent buyer a copy of the inspection report to serve as the seller's SPDS. Either of the above would be advised, at the very least. While both you, the listing agent, and the seller had obligations prior to the sale to disclose whatever you knew, that obligation was escalated by the fact that you both were provided information about potential material and/or latent defects via the BINSAR and inspection report. Some might argue that you are not permitted to share the inspection. That argument is often posed by the inspector. However, over and above that argument, the buyer is obligated to provide that to the seller per the contract, and once the seller has the report, there is nothing that would stop them from sharing it or using the information within it. The contract says, buyer shall provide seller and brokers, upon receipt, at no cost, copies of all inspection reports concerning the premises obtained by buyer. Bankruptcy. A seller's bankruptcy could be a material fact to a buyer. While bankruptcy could slow down a transaction, it typically would not prevent a deal from closing. Once a seller has filed their papers and has passed the means test and credit counseling, the courts will often attempt to fast-track a sale of real estate. The reason is simple. Typically, a debtor in bankruptcy often has their housing cost as the single highest expense each month. Selling a house might relieve them of some of that cost, and it might provide an infusion of some cash from their equity in the property. Several factors are involved here. First, if the owners have already filed for bankruptcy, can they list the property for sale? Yes, but they must have the listing approved by the court, and the court must decide who will list the property. That could be you, but you must work with their attorney and file a motion at the courts to be appointed special commissioner in order to sell the property. The courts will require that you provide certain information, including your listing, a market analysis, a statement of qualifications, etc. This process could take several weeks before the court approves both the sale of the property and you as the listing agent. It is best not to attempt to market the property prior to court approval. If, however, the seller files for bankruptcy while you have it listed, your listing is technically voided, since a bankruptcy technically voids any contracts for personal services, such as your listing. You would need to start the same process to be appointed special commissioner. In most cases, with the proper motion, the court will assign you to sell the property. In a few cases, the court might deny your request and appoint someone else. Either way, once in bankruptcy, the seller must disclose that fact to any buyer. Your listing should have the disclosure and contingency for the court's approval, as should any contract. Many sellers are embarrassed by a bankruptcy and will ask you to keep it quiet. You must inform them that a bankruptcy is a material fact and must be disclosed to any prospective buyer in the listing, and to the buyer in any purchase contract. If a seller needs to be convinced that the disclosure is required, remind them that any bankruptcy is a matter of public record. The disclosure in the MLS should be in the remarks, or as some MLS systems allow, a keyword or feature of the property. If the seller who has filed for bankruptcy is also seeking a short sale on the property, that complicates matters. While the court will almost certainly approve the sale of the property, the seller's lender will often reject a short sale from a seller who is in bankruptcy. Any seller seeking to short sale their property that are possibly going to file for bankruptcy or has already filed should seek legal counsel before proceeding. Short sales were very common during and after the recent recession, yet are rare today as values have increased and sellers are seeing more equity in their properties. A seller in bankruptcy is not, in and of itself, a problem listing, since the courts are seeking to relieve the owner of debt, while seeking to distribute any assets to creditors. The sale of the house generally accomplishes one, if not both, of those goals. One part of the bankruptcy issue for the seller would be the loan on the house that is included in the bankruptcy. If a notice of trustee's sale has been posted and recorded, a bankruptcy filing could stop the clock temporarily. As the listing agent, either taking the listing while the seller is in bankruptcy or files while you have it listed, you would need to know the status of their loan and if any trustee sale is looming. If there is a sale date coming and the seller files for bankruptcy, the clock stops. You could be right in the middle of an escrow on the house when this occurs. The lender would then need to file a motion called a motion for lift of stay, where they are asking the bankruptcy courts to lift the stay that the seller's filing created. The stay is a legal term, and the courts will entertain a motion if the lender can show that the seller has made no effort to make the payments. It could take 45 days for a motion to lift the stay to be heard and granted. All the while, you could be selling the house. Once the motion is granted, the clock starts ticking again, picking up where it left off when the bankruptcy filing stayed the trustee's sale. So, if the seller filed on day 52 of the 90-day time, the clock stops at 52. Then, maybe 45 days later, when the judge grants the motion, the clock starts again at day 53 and counts from that point. Thus, the seller bought themselves 45 days before the trustee's sale, all hoping to get the house sold. Foreclosure. We often use the term in foreclosure incorrectly. Being in foreclosure means that the lender has filed the notice of a trustee's sale and the date of trustee's sale has been posted. If this occurs on your listing, or on a listing you are ready to obtain, that means within a period of time, the owner will lose title and possession of the property unless he has it sold. Should your seller disclose that he is in foreclosure? That is a material fact that could affect the closing, and any buyer must be aware of that. A notice that is posted or recorded will show the date of the trustee's sale, so that must be considered if you are prepared to list the property. Technically, although easier to say, the term foreclosure in Arizona is incorrect. When a lender declares a property in default and starts the process to put the property up for auction, that is a trustee sale. A foreclosure is a process that involves a courtroom and a judge. That process is the only option in many states and is a costlier and more extensive process. In Arizona, since our properties are secured by deeds of trust and not mortgages, another word we use improperly, the foreclosure route, while still an option for the lender, is almost never used. The lender would much prefer to use the trustee's sale route as it is easier and less costly. And you might recall the debacle in many East Coast states with the robo-signers. That was all caused by the foreclosure process and the way the documents needed to be signed in order for the process to reach a courtroom. In Arizona, the process of a trustee's sale rarely involves the courts or a judge. What if the seller tells you he is 2 months behind on payments, but not in foreclosure? It might be considered pre-foreclosure. Does that seller need to disclose this to a potential buyer? Probably not, since nothing public has been noted. But if you take the listing while the seller is in pre-foreclosure, be sure to monitor the recorded trustee's sale dates to see if the lender has filed the notice. You could ask your title company to assist you in this, and be sure to have the seller let you know if he receives notice of trustee's sale. Certainly, check with your broker regarding the timing of any disclosure in this case.